1862. Court has received the following question from the jurors. There's a dispute about whether Peter stated a length of time from the accident till when EMS arrived on scene. Excuse me, we're on the record. Some jurors heard 2.5 hours from the accident till EMS arrival. Can you please clarify the time Peter stated in his testimony?
Good Lord.
Court reporter has prepared the following record. Question. Yes, sir, I do. Police officers. Yes, sir. Answer. Yeah. Because the first responders, the 5, they came 2 hours later. Question. They came later. Answer. A lot later. Well, I guess the police officers, one of their tasks was to identify my state, and probably they thought I can wait. Question. In speaking of waiting for when the crash happened until you left the scene, do you recall how long it was roughly? Answer. 2.5 hours. Any objection to that being sent back to the jurors?
Not from state.
Any objection to that as the answer state?
No.
None from defense, Judge.
Yeah.
Sorry.
I look towards you and I say state. All right. And let's go off the record.
Judge, and do you know if they were able to fix the technology?
Oh, good Lord. I thought we had a verdict. We've got a question, but I think a verdict will follow quickly. I'm just gonna hang out here quietly. I was trying to be Johnny on the spot with it, but as usual.
Which is number 1, wrong.
Yes. I have a bunch of great old videos on her.
Anxiety leads to constipation.
Who's here on Angus Talbot?
That would be me, Your Honor.
Yes, and where's Talbot?
He's in custody, Judge.
All right, Mr. Talbot, come down.
I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
All right, counsel, on this case, where are we on discovery?
We're still in the process of collecting discovery. In fact, I was in communications with the DA's office last week, and they were downloading it on thumb drives, and it's voluminous, and so I haven't received everything yet.
All right, and do you know, in this case, is there a lot of video?
I believe so. I think that's what the issue was.
All right, Ms. Ferguson, on this case, counsel, we're gonna reset it for 60 days for discovery.
Thank you.
And Mr. Talbot, if your attorney wishes you to be brought back sooner, he will let us know. Normally, I don't give 60-day resets for discovery, but due to the nature of the offense, I'm expecting there's the autopsy and everything else that you need to see.
Yes, sir.
All right.
Yes, sir.
What date, Ms. Ferguson? All right, we're gonna come back on October 7th, and that will be your last discovery date.
We have a co-defendant also that Mr. DeWalt wanted to join in on.
All right, and where's the co-defendant?
Sitting incarcerated.
All right, Mr. Talbot, do you have any questions about anything?
No.
All right, if you'll take a seat back in the box, and
Thank you.
Mr. McCarm.
Thank you, Judge.
All right, who's your client?
Your Honor, may I approach? And first, may I say I apologize. I forgot my jacket today.
If people forget jackets, what?
So hot. I ran into the office and the secretary took a 2-week vacation. I am no good without her. Don't tell her that.
Oh, I'm gonna tell her that, and her pay should reflect that.
All right.
Thank you,
Hold on.
Mr. DeLeon.
Hold on. There's cigarettes in here. And I don't know what it is.
Hey, Michael, care, custody, and control.
That's a
All right.
no.
Mr. Kawazo, come down. All right, Mr. Kawazo, how do you pronounce your last name? Kawazoe. I missed a lot of syllables in that. All right, we're gonna bring you back on October 7th. As I told the person previously before you, I normally don't set things off this far, but due to the nature of the offense, and I know there's gonna be a lot of discovery, I'll bring you back on October 7th. If your attorney wishes you to be brought over sooner, he can let the court know. Do you have any questions? All right, thank you.
But have a seat. I still want to talk. Can I talk to him or no? Judge, thank you very much. May I be excused?
Yes. Hey, don't leave without the jacket because I think you will have extended it. Michael, is that no good deed goes unpunished? All right. Who is here on Marco Marino? Hello. Hello. Mr. Marino, come on down. Remember, what page is he on? All right, I can't believe I missed that. All right, on this case, do we have CPS records?
No, Your Honor, this case just got indicted, and we're going to be requesting CPS records.
Oh, and when I say, do we have CPS records, I mean, is this a case that has CPS?
Yes,
Okay.
Judge. And then counsel will also be making an appointment to review the
Forensic interview.
All right, Ms. Ferguson, recall this in 60 days, please.
that will be October 7th.
All right, we're gonna come back on October 7th for discovery to make sure your attorney has everything. Do you have any questions? And again, normally I don't set things off this far, but due to the nature of the offense, and I know there's CPS records and there may be videos that your attorney may have to view. All right, any questions? All right, thank you.
Have a seat, sir.
Daniel Chopper the fourth. Daniel Chopper the fourth. Paul Padilla. Selena Lamone. Justin Zavala. No, he was late.
He was? Oh, that's good. I mean, bad,
Yeah.
good in a, not so good term. Well, I'll talk to him about that, and I'm sure the court will as well.
Okay.
I'm conferring right now,
All right.
and then I'll report back to the court.
All right, thank you.
I apologize for his tardy.
No, there is no need for you to apologize. You were not the tardy one.
Thank you.
All right, Taj Davis.
Oh, Judy, surely you jest.
Hello. You're looking, every time I see you, you're looking thinner. Are you okay?
I'm not in the kitchen no more. I can say that.
Okay.
Thought you were talking to me, Judge. Because I'm not getting
All right, every time I see you.
Exactly.
All right, what is happening with this case? Where are we?
This is a case where he pled guilty
Mhm.
and was given probation,
Mhm.
but he still has a parole hold. Right now.
Yes. Ah,
And so there was confusion over all of that.
all right.
I
So,
talked to his parole officer just a few minutes ago. He says he's going to set up a hearing for him. Going to talk to him tomorrow and set up a hearing. And that if we came back in 2 weeks, they would have some idea what's going to happen over there. I've given him an idea of what we were looking at over here.
Mhm.
He thought that it could be a very positive thing for parole.
okay.
And so if the court can give us 2 weeks,
All right, let's do this. I tell you what, I'm going to give you 3 weeks, but if everything turns out and it's done before 3 weeks, your attorney can always come back sooner.
Yeah, cause my preliminary hearing, he would come see me, and then like the next day or the following day after that, we would have the hearing.
Okay. All right, so we'll see what's happening, and then I'll make a decision. It's probably in your best interest that if they continue on parole, that you remain in custody so we can get you the treatment that's needed, as opposed to you're just out wandering around. All right? Ms. Ferguson, I need a 3-week reset.
August 26th.
All right, Ms. Abrams, I'll let her know.
thank you, Judge.
All right,
Thank you.
thank you.
Have a seat, sir.
Make sure you eat.
Hi.
Okay.
I don't have a problem eating, Judge.
I don't either, no.
August 26th.
Jamal
Thank you.
Moore.
No,
Ma'am, are you a whore? I object to the relevance of that, Your Honor.
All right, what,
I'll tie it up real quick, Judge.
all right, go ahead.
You're not a whore?
Any objection?
All objections.
Situation while in custody?
All right, do you believe do you think he's not competent?
No, not a mental health advice. I mean, a mental health, see if he needs mental health services, it's not a competency issue.
All right, then we need to go forward because if I were to decide to revoke him, then the fact that we're doing a mental health services, then what is the point of doing that? I'm not saying I will revoke him because I haven't heard any evidence. But other than that, is there another reason why this can't proceed?
I don't believe so, Your Honor. I will confer again with the deans.
All right, thank you. Oh, just have a seat, sir. All right.
So you're gonna have to give me some time so I can look at it. Yeah.
Writing three for this question.
Okay. All right, defense and state on this question.
Oh, we got law thingies.
Do you all want to compare it with the previous one that you agreed to? Let me print that out.
Okay, Judge.
Just 1 second. Hey, could I have that as well? I think so. Yeah, here you are.
Have one.
All right, so we're going to go briefly back on the record. In 2022 CR 11862. Have both parties had a chance to review the juror question state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objection to the answer as printed out by the court reporter state?
No, Your Honor.
Defense?
No objections.
Any objection to having this sent back to the jurors through the deputy, or would you like the jurors to be brought out?
No objection.
No objection to having it sent back?
Right.
All right, Deputy Laura? All right, thank
Thank
you.
you, Judge.
You're welcome.
We be excused for the time.
Stay close by.
Yes.
Yes, Your Honor, we just go out.
Sure.
So.
Find out.
Thank you. All right, who are the parties on Ricardo Gutierrez? Ms. Abrams, this is an application for deferred.
Afternoon, Judge.
Good afternoon. And is there a prosecutor available? This is Criminal Trial Division. Court is calling 2024 CR 6357, State of Texas versus Ricardo Humberto Gutierrez. Can I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Adrian Pettis.
And are you Mr. Gutierrez?
Yes, Judge.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gutierrez, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, Your Honor.
Did you understand it?
Yes.
Did you sign it?
Yes, Your
Did you review the true bill of indictment with your attorney?
Honor. Yes.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gutierrez, did you review the document entitled Court Admonishments with your attorney?
Yes, Your Honor.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes, I did. Yeah.
Did you understand you're charged with theft under $2,500 enhanced as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A
Yes.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gutierrez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $500 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing it, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, outside the agreement, the state is requesting that your community supervision be for a term of 16 months and that there be 100 hours community service restitution and a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
No objections.
All right, state, you may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it at all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed?
Yes, Your Honor.
What do you do?
Forklift operator.
Okay. Do you have any children?
I have two boys and I have two boys with my wife and one boy with my ex.
What are their ages?
23, 15, and 24.
All right. So you're here on a theft and hence why do you continue to steal?
I don't have an excuse that I stole, man. I just know that I wouldn't do it again, and I hadn't done it in over 10 years or so.
Well, you say you wouldn't do it again, but we're on here on a theft enhanced because you've stolen before. Otherwise, you'd be in misdemeanor court. So we're back to why you're stealing.
Immatureness.
Huh?
Immature.
How old are you?
44.
All right,
Step up so you can speak up.
44? When are you no longer immature? Because you're 44 and this happened in 2024. So that means at a minimum, you were 42 years old when you committed this offense. So what do you mean you're immature?
Well, the long answer would be that my family moved out. They were living with me and my wife, and when they moved out, it was a hardship on us because they were helping with all the bills. But my dad has a family violence on me, so that's why they moved out.
So your father has a family violence case
On
where you're the.
no, he assaulted me.
All right. So this is what I don't understand. The items that you're stealing, it's not food. Not that that's. All right, so everyone, no talking behind the court reporter. If you need to speak to your client, just ask the deputy to move them to the other end. We're on the record. All right, so what did you steal?
It was a set of binoculars, probably, and
All right, so you're stealing binoculars. Why?
and
I mean, it's not a rear window thing.
I bought. I was purchasing food, and I had got the binoculars just as a for the moment, like I just.
No, it says here that you took night vision optics. So some night vision. Is that the binoculars?
Similar to binoculars, yes.
All right, so again, why would you take that? That's not food, that's not anything.
I just want to see if I could make a buck, really, to see if I could make money off.
The LED light, that's not food. Why are you taking that?
I have no excuse, John.
And what is DMC BSK? What's that?
I don't remember, but
And then what is tanned? Is that for a tan? Is that a tanning product?
I'm not sure. It was maybe moisturizing option.
I'm sorry, what?
Moisturizer, maybe.
For $9.97?
I'm not sure. It could be tan oil. I'm not sure.
All right, why do you need tanning oil?
If that's what it was, I don't know if that's what it was. I'm not sure on that item. The exact items, I'm not sure, because I was purchasing like food and stuff too for the holidays also.
Yeah, it was a tanning product. I just see, yes. So you're stealing and you don't even know what you're stealing. And then you're taking night vision binoculars.
It's something I wouldn't do again. It was dumb. That's why I say I'm not trying to make excuses for what I did. I just know my freedom's worth more than those items.
All right, you act as though it's not though, because previously you stole and the other time you stole, it's Blu-ray DVD movies, a power pack, a Stealth Ball paint gun, Kenwood car stereo, a cell phone. I mean, you're just running around stealing and I don't understand why. And the reason why I'm asking you these questions, the state has agreed for you to be on deferred adjudication, but I don't know if you can be helped or not because it appears that your job is stealing.
Which is number one.
Well, no, I mean,
wrong.
it is.
Well, I have a job. I don't steal regularly, but I know it seems that way because over the years that's happened. But I think the scare I'm scared to go to to jail. I'm scared to have my freedom taken away. I'm scared to abandon or like just leave my kids without their dad and not have them get picked up from school.
When you're drug tested today, what are the results gonna be?
Clean for everything.
There you go. You're gonna get drug tested today. So what are the results gonna be?
Clean for everything. I don't smoke marijuana. I don't drink alcohol.
All right. Anything else?
No, Your Honor.
Court is gonna sentence you to 2 years deferred adjudication. There's to be no contact with Walmart. That's every Walmart, so you don't have to go somewhere else. Give somebody else business. There's a $500 fine that will be probated. Ms. Abrams, if we can do the CATS theft course, do they have a CATS 1 and 2 for theft? All right, it's gonna be CATS 1 and 2. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month for 4 months. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, 100 of those hours will be deemed satisfied. Probation, is there anything else? No, Judge. Is there anything else you need from the court to be successful?
Just the guidance that probation offers.
All right, probation will give you guidance, but you're going to have to not steal. You understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. And this court, communication is key when you're on probation. If you have an issue, let probation know. You understand? If you feel as though they're not addressing it, you can always come back to court. Do you understand?
Yes, Your Honor.
All right, and you're too old to be saying that you're immature. You understand?
Yes.
So no more stealing. If you steal, or if you commit another offense and a motion to revoke is filed, you're looking at up to 2 years in the state jail facility. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Pressure, good luck. So, excuse me. Thank you, Judge.
You're welcome.
Anything else?
All right, Catherine Aguilar. Okay, well, I haven't read any of it, so all right, what are we here for today?
Judge, we're here on appearance. This Miss Aguilar, if you recall, had a court date in late June. They didn't bring her from the jail, and we spent some time trying to figure out where she was. And that time you had a couple of interns, and we were calling TDC
Oh, yes.
and
okay.
all that. Yeah.
Now she's here.
Well, now she's here. Okay.
right, so-
But it was she was in ISL, which we did try to call at that time, and they denied that she was there. And so anyway, that was just quite a fiasco with knowing where she was.
Okay.
But anyhow, Miss Aguilar wants to. She's asking for time to hire private counsel on this case, Judge. So
All right.
she's saying that she wants 30 days to do that.
If possible. I have a family member and my ex-husband that are willing to provide financial help to obtain an attorney of my own.
All right, this has been going on since June 2024, and you've been indicted since June 2024. And an offer was tendered on that day, and your plea deadline date was set for June 25th. So what I'm going to do is, Ms. Ferguson, We're gonna recall this for August 15th. That's gonna be your final plea deadline date. If you hire an attorney, that attorney needs to be prepared. Do you understand?
Yes, ma'am.
Is there anything else?
No, Your Honor.
Did you receive my letter that I handed you?
I don't
Oh.
read the letters, and let me just tell you why.
Okay,
Because I don't want people to think that, oh, she got a letter, she's not reading it. This is the reason why I don't read letters that are sent to me by people who are accused. And I don't read letters that are sent by family members of the accused, because both the state and the defense need to have an opportunity to read those letters, because technically they're hearsay. And then if they don't have any objections to me reading the letters, then I will read the letters.
okay, I did not
So
know that.
for example, I've been told that I have your letter, I have the letter and emails from other people, but I haven't read any of those.
Yeah,
Okay.
and I have not read the letters that Ms. Aguilar had written to you, Judge. And
Okay.
I asked her, I think she prefers that I not read it.
I don't care either way. I just, even if I can't get my own legal representation, I would like a new public defender. Only simply for the fact that he was my court-appointed attorney 2 years ago when I originally caught this charge. And I sat in here for 90 days and never heard from him again, ever.
Mhm.
And I called him, wrote him, everything.
Oh,
and
let me
I never-
explain something to you. In this court, the counsel that's been appointed to you, that's your counsel.
Yes, ma'am.
If you want another attorney, you're more than welcome to hire one. This is your counsel. He's been appointed to represent you. And by his appointment to represent you, that tells me that he's followed through and he's qualified according to the guidelines that have been set.
Yes, ma'am.
So that's where we are. So this is your attorney.
Yes, ma'am.
All right, anything else?
No, ma'am. Thank
that's
you.
it.
Thank you, Mr. Cano.
Okay, thank you too.
David Coyote Vargas. Okay, thank you. Oh, and can you do the file stamp on that? Because I don't have a.
Hey, Judge, how are you?
How's it going?
Good to see you.
Oh, you too? All right, today is plea deadline date.
I've been waiting for Zach. I guess he's at a meeting with a victim on another case, so I
Mm-hmm.
conferred with the first chair. We just got the offer, a few minutes ago. So I was gonna ask if we can have some time, talk about it, think about it, and maybe talk to Zach some more.
All right, Ms. Ferguson. If you recall this for August 22nd, that will be your final plea deadline date.
Appreciate it, Judge.
And this is Vargas, Norma? Yes. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Good seeing you,
You too.
as always. Great flowers.
All right, who's here on Aaron Moore? All right, and did you all confer with probation? All right, so I'll take that as a no. All right, so if you all will speak with probation, and then once you've done that, I will be ready. Oh, you all ready? Okay. All right, Mr. Moore, if you'll come down. Court is calling 2021 CR 8754, State of Texas versus Aaron Jamal Moore. Can I have parties announced for the record for the state?
Allie Jackson.
Defense? For the defense?
Catherine Valenzuela.
Are you Mr. Moore?
Yes, Your Honor.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Aaron Jamal Moore who was placed on community supervision in 2021 CR 8754 for the offense of assault family second offense on October 26, 2021 for a term of 7 years? Is that you?
yes, Your Honor.
State?
Your Honor, we're proceeding on violation of condition number 2, that on or about the 24th day of November 2021 in Bexar County, Texas, The defendant, Aaron Jamal Moore, did then and there fail to submit to drug testing as directed by the court officer, or supervision officer, and or duly recognized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
That's true.
All right. Off the record for a moment. Defense, if y'all move down to that end. All right, we're back on the record. State,
And we would waive the other.
any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 7 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor. The proposed agreement is that we alter and amend for a mental health evaluation and TAP in custody. According to the notes of his probation officer, when he last appeared back in 2022, he was talking about, he was feeling that he was going to relapse, and it seems that that's what he did. He absconded and relapsed, Your Honor. That's why they're recommending that we do the mental evaluation and TAP while in custody.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Mr. Moore, are you asking the court to follow that agreement?
Yes.
Defense, anything you wish to add to the record?
Yes, Your Honor. Just for further clarification, Mr. Moore, we have discussed that he does indicate that he did indicate to probation that he did have mental health concerns. He was very troubled about, well, especially his grandmother being ill. She passed away last year, 2023, and he was picked up and has been held in custody since July
July 2nd.
of 2023. So he's been in custody this whole time. So he hasn't.
Well, you're not saying July of 2020, correct?
Correct, Your Honor. So yes,
24.
you're right. I know.
Okay.
Yeah, there's,
July of 2023, Your Honor.
yeah, we're not, but I mean, it just,
He's been in other jurisdictions.
he's been in other jurisdictions. Yeah, so it's not, we're
Other
arguing the
ju-
length of the time, not that there was time that.
All right, so when you say he's been in other jurisdictions, is that for other cases?
We show you.
I believe so, yeah.
They're not alleged in ours. I haven't received any evidence about them.
All right, what are these other cases? And the reason why I'm asking is because depending on what the recommendations of the TAP evaluation will be and what the recommendations with regards to mental health will be, if he has outstanding cases in other counties, they're not going to accept him.
No, I believe he has disposed of all those cases.
Yeah, I don't have anything
And-
outstanding.
And they were.
Which is number
old
one.
Cases prior
Wrong.
to the pendency of this case, Your Honor.
Yes, Your Honor.
All right, and when we say he's disposed of those cases,
He served time.
are we taking Mr. Moore's word that he has disposed of those cases, or do we independently know?
I do.
And Mr. Moore, I want you to let you know, I'm not saying that you're being dishonest, but sometimes what the accused think of as disposed, sometimes it's not really disposed of. So does anybody know?
No, but he was brought over while in custody. I mean, so he transferred from their possession to San Antonio's possession, I would believe. Typically that they don't bring them over if they're still.
No, that's
Okay.
not true.
Yeah, say no. Sometimes we ask for them or other things.
All right, probation, what is your recommendation?
Judge, according to the court summary, it is what has been discussed, the mental health evaluation and counseling will follow all recommendations.
What is TAP?
All right, this is what the court is going to do. The court will deny the motion, alter and amend conditions to include a mental health evaluation and TAP evaluation. That is to be in custody. He's not to be released until the mental health and TAP evaluation are completed and to follow all TAP recommendations. So if TAP evaluation recommends that you're to be in inpatient treatment, you're going to be in inpatient treatment. Do you understand?
Yes, could you expound on like specifics of inpatient? I'm a little bit.
Oh, so if you have a drug or alcohol problem and they deem that the only way to help you is to place you in an inpatient facility, similar to the Betty Ford Clinic. Have you ever heard of the Betty Ford Clinic? All right,
Wow.
it's the Bear County version, right?
Right.
So if they deem that you need inpatient care to address mental
Bear
health
County,
issues,
Betty Ford
to
Clinic.
address any drug issues,
Only on
then
Let's
you're
Talk with
going to
Mike.
go from the Bear County Jail to whatever inpatient treatment they recommend. If your attorney feels as though inpatient treatment is not appropriate, she can always come back and the court will hear it. Do you understand?
Yeah.
That's yes.
Yes, you do.
All right. We can go off the record. In this court, communication is key. I do appreciate the fact that you picked up the phone, that you called your probation officer and said that you thought you were going to use or that you were having issues. That's a good thing that you did that. Next time when you pick up the phone, well, I know there won't be a next time. But if you pick up the phone and call them and you have an issue and nobody gets back with you, come to court and we'll address it. Okay?
Okay.
All right. Anything else?
Nothing
So-
for the.
So will I have another court date?
No, not unless your attorney requests it.
Oh, okay.
Yes.
So I'll
So
just-
this case has concluded as far as the allegations that you violated your probation.
Okay,
The
so
only way you'll have another court case with me is if you pick up another motion to revoke.
okay, so at this time, I'm just waiting for evaluation.
Yes.
Okay, thank you, ma'am.
And the probation officer will be able to tell you when your TAP evaluation may take place.
Okay.
Thank you.
Thank
Anna.
And Judge, she's not going to have a court case needs to confirm.
Yes,
And we understand that.
yes,
We will-
and then you have a county court at law case to take care of. Here's the thing, any cases that you have pending and are open, if you're recommended for inpatient treatment is not going to transfer you to inpatient treatment as long as you have cases that are open. So you have a misdemeanor case, the DWI case,
Mhm.
if that is not taken care of, they're not going to transfer you.
So I'll be in limbo until I get that done.
Yes.
Correct.
Okay, thank you.
When,
All right, you're welcome.
thank you. Anna.
Thank you. Anyone else ready?
I believe that they're working on it.
All right, thank you. Paul Padilla. Selena Lamone. Armando Garcia.
Present, Your Honor.
All right, yes. On this case, I see he has a new number one.
Judge, he's got two unindicted assault charges that have not been indicted yet. And he's got an MTR in here. So there's not much for us to do per se. So what we're looking for is a reset judge, and hopefully the district attorney's office will eventually get around to his intake.
All right, and with regard to those other cases, has that been included in the motion to revoke or no?
It has, Judge, in the supplemental.
All right. So do you have all of the discovery in those cases? Are you the attorney on those cases?
I am. I don't have the discovery at all on the new number ones.
All right, and is this criminal trial division or family
It
violence?
would be criminal trial, Judge. I have not conferred with them because they're not going to know anything.
They may know something. Criminal trial division. Michael DeLeon has just stated that you all may not know anything about this, but I think you will.
Know something? Probably.
All right, so it's on Mr. Armando Garcia. He has a motion to revoke. And my understanding, there are unindicted cases.
I mean, I didn't speak to Mr. DeLeon, but I can give you it.
All right, so do you think you'll be able to give him discovery on the new number ones?
On unindicted cases?
Yes.
If Mr. DeLeon was able to give us some sort of flash drive, something that I can use to put on, that is something on.
All right, Ms. Ferguson. On Armando Garcia. Set this for a contested hearing in 30 days, please. And Mr. DeLeon, if it becomes uncontested, then we will go from there.
That's fine, Judge.
All right, September 5th.
Sounds good, Judge.
All right, thank you. You have any questions?
I'm back.
All right, we will see you back on September 5th. Bashan Armando Garcia, contested September 5th. Yeah.
Judge, may I approach? again?
Yes.
I think we have Nieves Carrillo on the docket.
Yes.
She once again wasn't brought over, Judge, because she doesn't wear clothes. So from the
All
jail.
right. Could I see the file on Nieves, please?
Additionally, I think she she was competent and she has moved back to incompetent. The doctor from the jail called me.
He says that like it's a bad thing.
Nieves Carrillo. Carrillo, I'm sorry. Got my double
Wow,
L's.
Look at you, Judge.
I'm improving. Yay. All right. Deputy Laura, my understanding she wasn't brought over. All right. So what we're going to do is I guess she's being reevaluated.
Oh, yes.
All right. Ms. Ferguson.
Yes.
On Carrillo, if you'll set it for 60 days, please.
Awesome.
Yeah, I'm guessing it probably is a bad thing.
Okay. All right. Thank you.
Senior citizen. And Judge, premature, but tomorrow I've got a trial setting, so I'll be back for that.
And who is your client?
Virginia Serna, superstar.
Let me just tell you, it may end up going.
And when will we pick a jury? Afternoon?
Afternoon.
Okay. That sounds good, Judge. And maybe the state will, give me some discovery.
Oh,
Stop violating the Brady notices.
you want to check in with them now?
Probably should a little bit. Thank you.
All right. Thank you. You don't see. Yeah. Yeah, that's true. Yeah.
He's got to keep pressing. Yeah. Gotta keep pressing.
Thank you.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked
All
some
right,
glue
and Norma,
and
just
stuff.
give
I
me
thought I
2
was smoking
minutes.
crack.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, that being
I never want to hear it again.
You a whore?
Mr. Sharts,
Not a whore?
Mr. Sharts, Mr. Sharts, Mr. Sharts.
You're not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? You're not a whore?
I never want to
And
hear it
then
again.
had to go over there for. Okay.
Counsel, what's your next? Okay.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up.
It goes up there.
Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up. Jump on his wiener. Cat jumped on his wiener. Shut up.
Okay, we're done. Now give me step back. Thank you.
swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I suppose.
She's paying for We're paying for her trafficking.
This is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please hit like and subscribe, or I'll be personally offended.
All rise.
All right, everyone, please be seated. All right, who's here on Donnell Green?
Judge, I am present on Mr. Green.
All right, Mr. Green.
Sir, what is your name?
Marshall White.
Right.
That's right.
Court is calling 2024 CR 007470, State of Texas versus Donnell Green. Can I have parties announced for the record for the state?
Adam Jackson.
Defense.
Marshall B. White and Mr. Donnell Green, the defendant, Your Honor.
Are you Mr. Green?
Yes, Your Honor.
And counsel, there are no applications?
There are not, Judge.
All right, Mr. White, have you received all the discovery in this case and did you review it with your client?
I believe at this time I have, Your Honor, and we did go over that.
All right, court will find that the state is in compliance with discovery. Mr. Green, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeded on the lesser included of attempted violation of sex offender registry. It'll bump down to a state jail.
Any objections?
No, you.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of violation of sex offender registration annual to attempted violation of sex offender registration annual as a state jail felony?
Yes, Your Honor.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not, I'm sorry, off the record.
Sure copy of this, Mr. Green. Okay, put it in your pocket.
No, it's the correct paperwork. I just have a question from the jurors.
Don't be so,
I'm making sure. It's been years since I.
All right, Norma, if you can call defense attorneys back, please. Thank you. Can you hand that to the state? All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Green, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did, Your Honor.
According to the plea, punishment is to be assessed at 95 days in the Bear County Jail under 1244. Did you understand that to be the plea?
That was my understanding, yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understand.
Counsel, have there been any such motions?
No such motions, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
And I'm sorry, that's to the lesser included offense. No contest? State, any evidence?
State of State Exhibit 1 with all attachments.
No objections, Your Honor.
All right. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial? A right for you and your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent.
I do understand, Your Honor.
Did you understand that the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Right, could I have those documents that are printed? It should be 2. Thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, Mr. Green would like for the court to know that he's very remorseful about this matter, that he does not expect for this to happen again, and that you go along with the plea bargain agreement and plead with the state.
All right. Court will sentence you to 95 days in the Bear County Jail, give you credit for any time served, and that's 95 days under 1244. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it?
That's the document you have.
Oh, yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I do, Your Honor.
All right, we can go off the record. Make sure you report, otherwise you will be right back here. Do you understand?
I understand.
All right, thank you.
Thank you very much. Have a
Thank
good
you,
afternoon.
All right, you
Mr.
too.
Green, good luck with you, sir.
Norma, which page was Mr. Green on? Thank you.
Thank you.
All right, Mr. Gahan. When the defense appears.
Yeah,
If you can
these
give
are the
that-
questions. I read them, Judge.
Yeah, no,
Oh,
if
oh,
you
you
can-
already have it.
For the
Okay.
defense, and those are the proposed
Oh, okay, sorry.
answers.
Okay,
All right, who's here on Joshua Wong?
I agree.
Oh, no, if you can give it to the
Oh.
defense when they show up.
Oh, when they show up. Oh, sorry.
Thank
I
you.
guess I should listen.
No problem. Court is calling 2024 CR 2313, State of Texas versus Joshua Wong. Can I have parties announced for the record for the state? Defense?
Scott McClung for Mr. Wong.
And are you Mr. Wong?
Yes.
Counsel, have you received all of the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wong, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Off the record, your client needs to sign that.
Sorry. This was,
All right.
remember I talked to you about you were waiving your right to appeal if the judge follows the plea agreement.
Thank you. All right, we're back on the record. All right, did you understand you're charged with terroristic threat of a public servant?
Yes, ma'am.
That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe.
Mr. Wong, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense is at the plea.
It is, Your Honor, with the understanding that I would ask the court if you would consider probating the fine. He's a high school student.
All right, state is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no possession of any weapons on school grounds and within 1,000 feet of any schools. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
State exhibit number 1 with the office.
No objection.
All right, state, you may continue to confer. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
exciting and new.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please, Judge.
Anything you wish to say on behalf of your client?
Judge, this young man has never had any trouble with the law before. He's never even had any trouble at school before. He realizes what a dumb thing this was that he did. He's been allowed back into regular classes at his school. He attends a youth ministry, I think 4 times a week. We're not gonna have any problems with this young man again. I'm certain of it. So I hope you would just follow the agreement and that's all.
All right, why would you do such a thing? Why are you putting this on social media?
Sorry, I just didn't meant to do it.
I'm sorry, what?
I didn't meant to do it. I just.
No, I mean, you meant to do it because you did it. I'm trying to figure out what was your thought process behind doing what you did.
Just did it for fun.
All right. And now look where we are.
Yes.
You need to start thinking before you act, and doing things for likes or whatever young people are doing now. It's not worth it. You understand?
Yes.
So has he received any type of mental health treatment?
No, Judge, I haven't seen any indication that he's ever had any kind of issues before. And talking with his family, they were just shocked by this. He's been a good kid and by all accounts goes to school, does well in school, is in, like I said, youth ministry.
What are your grades like in school?
My grades?
Mhm.
They're good. They're grades.
What does that
like
mean?
what?
Everybody has a
What kind of grades?
definition of good.
Like 80s, 90s.
Okay, 80s, 90s. And they've changed the grading scale from when I was in school. Now an 80 can be an A, which is unheard
Well, I
of.
don't think 80 could be an A, Judge.
Yes.
89 maybe could be an A minus.
When I was in school, 90, you were just on the cusp of
That's an A
being at
minus.
a B. No, 90, when I was in school, that was the cusp of the B. You're not really pushing an A. You're just
Yeah,
praying,
yeah.
So what do you do in your spare time? Are you involved in any extracurricular activities?
No.
Well, tell him about the ministry that you're youth.
Well, I'm in a ministry like church. I go to church, like they have a youth program.
All right, everyone, you need to whisper.
They
Yes.
have a youth program and I go.
So
Tell
what
her
do
how
you do in
often
the
you
youth
go.
program?
I go Mondays. Well, I go like almost every day.
All right, so what do you do there?
Like we pray, we sing, and then yeah, they like give us a lesson.
All right, are you involved in any school clubs or sports?
No.
Why not?
I'm not interested.
All right, well, I will tell you, different clubs at school, that's a way to meet with your peers. And a lot of times people think being on the football team or basketball team's the end all to be all. I was president of the physics and chemistry club. So it's just, you're meeting people
Somehow I
who
believe
maybe
that.
have your same interests that you do. So you need to figure out what your interests are and what
Demented
you're
and sad,
planning to do with your future,
but
because
social.
it's not too late for you. So you need to start focusing on that, because this is a bad start to the rest of your future, but you can still turn it around. Do you understand? All right. So does anybody want him off of social media?
I don't.
Is he going to go through withdrawals if he's not on social media?
I mean, any kid his age will probably go through withdrawals not being on social media, but maybe for a short period if you're inclined.
Okay. Well, I will tell you what I am going to require though, and I do this for a lot of the younger people who are on probation. You're still in high school. Technically, you're an adult according to the law, but I still think sometimes they need some extra guidance. So I am going to require you to check in with me so we can make sure that you stay on the straight and narrow. So other than probation, you're going to end up coming in to check in with me. And I'm going to make sure you check in with me. Probably we'll do it once every 3 months just to make sure that he's on track. And if you have any issues, you can discuss any issues that you may have with me or maybe with your attorneys, because sometimes I know people don't want to discuss certain things with their parents. I personally don't encourage that. I think you should be able to discuss everything with your parent as I did with mine. But sometimes people want to hear it from a stranger. All right? So this is what we're going to do. There's a $2,000 fine. That's going to be probated. Ms. Abrams, this is one person. I'm not going to do proof of employment because you're in school full time.
Yes.
All right. So I'm not going to do the proof of employment with him. I'm going to do 5 years deferred adjudication. Counsel, if he completes everything successfully, the court will consider releasing him. And if you want to be released early for probation, it will be good for you after you graduate from high school to get in somebody's trade school or go to somebody's college. Then I will strongly consider letting him off early. There is going to be 200 hours of community service restitution. I'm going to make you do that. You can either do the 200 hours of community service restitution, or you can join an organization at your school. And the hours you spend in that organization at your school, for every hour you do that, that'll be an hour less of community service restitution you have to provide to the court. You understand?
Yes.
And the reason why I'm doing that is because I want you to get to know the other students. Sometimes people are very shy and they think they don't have anything in common with other people, but you will find that probably the same insecurities or issues that you're going through, somebody else at school is going through the same thing. And they're just waiting for somebody to say, hey, I feel that same way too. You understand?
Yes.
There's going to be regular reporting. And Bashan, all right, off the record for a moment.
That better be because there's a verdict.
Just give me one moment.
Yes.
Do you all mind stepping back just briefly? I just need to give this supplemental to the juror.
Yes, Judge.
Oh, good Lord. We got a juror or two overthinking this thing.
All right, and then, okay, I'll have that printout, please.
Judge, may I approach?
Yes, State,
These are the,
we have another question.
okay, I'm gonna leave these here for you, Judge. Okay.
Oh, no, we're gonna do it right now.
How much wood would a woodchuck chuck if a woodchuck could chuck wood? That's what my money's on.
All right, so we're gonna go on the record. In 2022 CR 11862, court has received the following questions from the jurors. May we please have examples of substantial and unjustifiable risk? May we please have the legal definition of substantial and unjustifiable risk? Can you please provide the definition of reasonable doubt? Have both parties had a chance to review the questions? State?
Yes, Your Honor.
Defense?
Yes, Judge.
Court proposes the following answer to each question. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objections, State? Defense?
No, Judge.
Any objections to sending the answers back to the jurors? State? Defense?
No objection.
And let me put them in.
Oh my God.
Thanks.
Some bleeding
All
hearts
right,
gonna try
Mr.
to
McCrum, if you and your client will come back,
let this
please.
guy off.
All right, Ms. Abrams, and we're back on the record in
Yeah, that's the usual
2024
response.
CR 2313. In this case, because he's in school, can we do reporting by Zoom? All right, so there'll be regular reporting by Zoom. And I'm doing that because I don't want you to miss school. Field visits. One time per month. For 3 months. And while you're on probation, you're not allowed to have possession of any weapons. So the request for no possession of any weapon on school grounds and within 1,000 feet of any schools, you're just not allowed to possess weapons, period. Do you understand?
Yes.
And there'll be regular random UAs. And counsel, he can do the UAs or either he can do the patch. The patch costs more, but regular random UAs, it may end up being a little bit difficult, Miss Abrams, since he's in school and I don't want him to miss school. So,
What time do you go to school every day?
4:15.
Yeah, it could be tight.
yes, he gets out of school at 4:15. So if he's not able to do that, you're gonna have to do the patch because you have to be drug tested. Do you understand?
Yes.
Judge, unless you give them 24 hours to submit after.
All right, I'll do regular random UAs with 24 hours to submit.
Thank you.
And a mental health evaluation. And that can be done out of custody. Probation, is there anything else he needs? Is there anything else you need from the court?
No.
All right, Ms. Ferguson, on this case, can I have a 60-day reset?
Yes, ma'am.
All right, so on October 7th, you're gonna come in. You'll probably be a little bit late for school, but if he's here at 9, I'll take him up before before my docket is called, because I want to keep track of him and make sure that he stays on the path that he's supposed to stay on.
Very good. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal
Yes, ma'am.
with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed the plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 10 years? If the answer is yes, don't do it. You understand?
Yes, ma'am.
Do you see everybody over in that box?
Yes.
Those are inmates that are brought over from the Bexar County Jail. And the fact that you are of your age, the inmates at the jail are not going to care because you're going to be legally an adult. So you need to make sure that you stay on the straight and narrow so you don't end up at the Bexar County Jail or that you don't end up at prison. You understand?
Yes, ma'am.
And in this courtroom, communication is key. Talk to your probation officer. If you feel as though you're struggling with conditions, pick up the phone, call probation, call your attorney. If you feel as though they're not addressing it, you can always come back to court and address it with me. You understand?
Yes, ma'am.
All right, good luck to you. And thank you for dressing appropriately for court.
You're welcome.
All right, thank you.
Judge, does the court need to do anything for his conditions of bond to be, because he's on a monitor?
All right,
He's been on it without fail, hasn't been able to do anything.
all right, this is what, is he on,
Full GPS,
full GPS?
other than being able to go to church.
All right, I'm gonna allow him to go to school and I'm gonna allow him to go to church and then he can come back and I'll consider
He's
things.
been on for quite a while already, Judge.
Okay.
He's not gonna,
Okay, let me just tell you. I've had young people to come to this court before who've had similar charges to him. And I've got to make sure that you stay on track. Because if you think about this case, not as your case, just as a case in general, what you did, that puts everybody on high alert. You understand?
Yes, ma'am.
I know you may thought it was a joke, but with what's happening in the world, other people did not think that was a joke. And that probably disrupted a lot of schools and disrupted a lot of students and gave them anxiety. And it probably gave parents a lot of anxiety. So the fact that you're on GPS in the big scheme of things balanced against what you've done, this is where we are. Okay? So when you come back in October, what I will do is I'll start slowly, if everything is going well, I'll start slowly lifting you from that. Okay?
Judge, I need
What do you need?
I need more instructions on the details.
All right, on the GPS, it will be partial for school. And you said you have your church activities?
Yes.
For school and for church activities.
He's got community service.
Oh, probation, this GPS is not gonna stop him from reporting.
Whatever his probation terms are, that's fine.
Yes,
Is that your work release?
yes.
Very
No, work release waive fees.
Is that all?
Yes, that's
Thank
it.
you, Thank you.
Thank you.
Is there one for the October date? I don't need one. Do you? What was it?
Ms. Abrams, the answer to your question is yes. Whether or not he can appear by Zoom before school starts.
Okay.
Yes. Who's here on Andrew Estrada?
Here.
Yes, Anita Perez, actually.
All righty. All right. Court is calling 2024 CR 0350, State of Texas versus Andrew Thomas Estrada. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Anita Perez for the defense.
And are you Mr. Estrada?
Yes, ma'am.
All right. You entered a plea of guilty on April 4th. According to the plea bargain agreement, the punishment is to be assessed at a cap of 7 years in the prison, and the state is silent on your application. And both parties agreed to waive the PSI, and the court requested the TAP evaluation and also the defendant's criminal history. Defense, have you had a chance to review the TAP evaluations?
Oh, me? Yes, Judge, I have.
Okay. Any objections to the TAP evaluation?
No, Judge.
All right, and state, do you have the criminal history for the court?
Yes, Your Honor, handed the judge the NCICT CIC.
Any objection to the court review?
No, Judge.
And
No, no
defense, have you had a
objection.
chance to review?
Yes, I have.
Everyone, just give me a moment.
Yes, ma'am.
State.
I can't even reach, sorry, Judge. I'm too short.
No problem. All right, the state is silent on application. Any witnesses, defense?
No, Judge, just my client.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew Thomas Estrada.
All right, defense.
Okay, Andrew, so do you know what you're here for today?
Yes, ma'am.
And can you tell us what that's you, what you're here for?
I'm here for an evading arrest with a motor vehicle charge.
Okay, and previously we had court on April the 30th. Can you tell the court what happened that day or why you weren't here on the 30th?
On April 29th, I was in here for a decision that I made. I knew that I was gonna be incarcerated and I had some things that I had to take care of outside, such as getting the custody of my kids into my mom's hands.
And I'll stop you right there. So, can you tell us when you were arrested for the DWI?
I cannot tell you the exact time.
Okay, so if the PSI, oh, I'm sorry, if the TAP evaluation says April 24th, does that refresh your memory
April 24th is,
that you picked up the DWI?
oh yeah, I picked up a DWI in Nueces County on April 24th.
Yes, that's a charge I'm talking about. And do you remember picking up that charge?
Yes, ma'am, I do.
So are you currently on probation in another county?
Yes, ma'am, I'm currently on probation for San Patricio County.
And now it's correct that you started probation on 2022 and you're on 5-year probation, right?
Yes, ma'am, that's correct.
And our hope was that we would continue probation in San Patricio and that you would be granted probation here. Is that right?
Yes, ma'am, that was the original
Agreement.
hope that we had.
And that's why we agreed to the cap of 7 years. Is that right?
Yes, ma'am.
And at this point, we negotiated with the state and we asked if we could withdraw our plea and that wasn't agreed to. Is that right?
Yes, ma'am, that's correct.
Okay. And so are we, are you asking the court to consider all of that, and especially with the new charge? Are you asking her to take that into consideration that we've obviously changed our opinion?
Absolutely.
Now, do you believe that you will be continued on probation in San Patricio?
That I do not know and to answer honestly. I could only hope that I would be continued on probation with them or.
But we don't know, right?
Yes, ma'am.
Okay, and have you been to ISF?
Yes, ma'am, I went to the CBR ISF located in Sinton, Texas.
Okay, and did you attend from May 24th through June?
I believe it was from May to January.
Oh, I'm sorry, yes, that's correct. Did you attend from May through January?
Yes, ma'am.
And did you complete that successfully?
Yes, ma'am, I successfully completed the CBR ISF treatment phase, the cognitive phase, and the aftercare phase.
Okay, let's see. Can I have it marked? Can I borrow, do you have a sticker? Great.
Counsel, if you want the court to just review that so he can still keep his certificates.
These are not the originals, Judge. I'm gonna put it on the record.
All right, thank you.
You want me to just do it one or one? Mr. Estrada, I'm handing you what's been marked as defendants exhibit 1, 2, and 3. And do you recognize these documents? Don't tell me what they are, just tell me if you recognize them.
Yes, ma'am, I recognize it.
Okay, and are they true and accurate copies of
Yes,
the
ma'am.
documents that you
Yes,
believe
ma'am.
that they are?
Those are photocopies of the certificates I received for completing the program's requirements.
And you believe that these are true and accurate copies of those certificates? Is
Yes,
that right?
ma'am.
Okay. Any objection? No. All right, so at this time, we're asking for the defendant's exhibit number 1, 2, and 3 to be admitted, Judge.
All right, 1, 2, and 3 is admitted without objection.
Okay, now, since they've been admitted, can you tell me what they are?
One of them is gonna be my MRT, moral recognition therapy. The other one would be cognitive treatment, and then the other one was the aftercare.
And because we waive PSI, Judge, I know that there's no PSI, but do you want me to ask my client about his prior criminal history? I mean, is that helpful to the court?
No, well, I reviewed the NCIC and TCIC, but I do have some questions.
Okay.
All right, the questions I have is that the classes that he completed, the dates on them, completion date, are from 2023.
They should be 2024, Judge.
No, they say 2023.
Yes, ma'am, I see that. It must be like a misprint because I was
Yeah.
released the day after I got those. certificates.
Because the ropes are pretty tight. Miss Prince. My mic is underneath the papers.
All right.
I
I
was-
haven't,
I was discharged January 9th, 2024. So. And it's on my, the criminal history that I reviewed.
All right, so January.
Yes, ma'am, of 2024.
All right, so January 2024, I have this successful completion, right? And you're saying the dates are from 2024?
Yes, ma'am. That was when I was released from the ISF in Sinton, Texas on January 9th, 2024.
I have another letter for the court if the court is,
Yes.
do you recognize this document?
Yes, ma'am. That
And-
is from my probation officer at the
What-
CBI.
So it's a letter, right?
Yes, ma'am.
And is it a true and accurate copy of the letter that was, actually, she emailed it to me. But is that,
Yes, ma'am.
okay, so at this time, we're asking that defendant's exhibit number 4 be admitted. From the probation officer.
Objection, Judge.
All right, defense exhibit number 4 is admitted without objection.
Yes, Judge, so that letter was emailed to me by his probation officer out of San Patricio. And I believe that should hopefully clarify the dates, because in that letter, she states that he was released January 9th of 2024 as his testimony. I don't know why the certificates would be incorrect, Judge. I didn't even. let's see it.
And then you stated the reason why you didn't show up for court because you thought you were going to be taken into custody and had other things that you need to take care of?
That is correct, but when I said other things that I needed to get custody of my kids, taking care of power of attorney to my mother and get other financial situations that I had to get taken care of before I turned myself in.
So after taking the moral recognition therapy, which is supposed to help you with your thought process, your thought process was, let me not show up to court because I think I'm going to be taken into custody. So I'm not going to show up. I'll just deal with that later. Is that what you're telling the court?
Yes, ma'am.
Okay. All right. He's still making a bad decision, it appears, to the court.
Yes, that's correct, Judge. I mean, do you acknowledge that you have any problem with any substances at all you won't tell the court about?
I do have a problem with alcohol. That is the whole reason why a string of bad decisions was made and I did not go to court.
So he didn't come to court on for sentencing on April 30th, 2024. And this DWI that he committed, I'm
It's
assuming
pending,
he's
Judge.
pled to it. Is it still
No.
pending?
It's still pending. I called Nueces County, and it's not even filed yet.
All
They
right.
take a while to file their cases. I think they
All right.
usually will file it right under the statute. I did call Nueces, I did call San Patricio County, and they filed the MTR on June 14th, 2024. So after this, Judge, I'm assuming he's going to be transferred over there to have the
My question is, the DWI, and it's just an allegation.
Right.
When is that alleged to have occurred? Does anyone know?
April 24th, Judge.
All right.
Yeah,
So
that's-
instead of, he comes to court, he enters a plea of guilty on April 4th. And then April 24th, he is charged with DWI. And then he doesn't show up on April 30th. So you're concerned about your children, so concerned that you pick up a DWI on April 24th instead of getting your affairs in order. Is that the sequence of events for the court?
That was a sequence of events, but not the sequence of my thoughts. When I caught the DWI, I called my probation officer in San Patricio and let her know within the 2 days that she needed to hear from me. Once I let her know, she said she was gonna let the TAP evaluation officer know. She notified me on Monday that the probation was off the table and that she was gonna go ahead and recommend incarceration for me the following Tuesday. So I wouldn't say that I made the best decision possible for me or my family, but
So was it a catch me if you can situation?
No, he turned
absolutely
himself
not.
in,
I
Judge,
turned myself in.
When?
about a month ago.
Yes, about a month ago. I believe it was
I have it written
it's on the 9th of July, I believe.
All right. So you didn't turn yourself in on May.
No, ma'am.
You didn't turn yourself in June.
No, ma'am.
So you turn yourself in July.
Yes, ma'am.
And this power of attorney for your mom, how long does it take to write out documentation to say, I want my children with my mother? That's not even a day.
Yes, ma'am. Also during this time period, I did call the Bear County clerk and I was asking about a warrant for my arrest.
No, we're not about the warrant right now. Where I am is, you said you picked up this DWI. You didn't come to court because you thought you're going to be taken into custody. So instead of coming to court, you don't show up. And part of your reason for not showing up, you said, was because you needed to get your affairs in order, to get a power of attorney to your mother for your children, correct?
Yes, ma'am.
So a power of attorney to your mother takes 30 minutes tops. And so you didn't report for the full month of May and didn't report for the full month of June.
No, ma'am, I did not report.
Okay. All right, this is what the court is going to do. The court is finding you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, I'll recommend the therapeutic community for you. It doesn't increase the length of time that you're in custody, but I'll recommend it. And if you sign and request it, they may consider you for the program. I don't have the authority or jurisdiction to force them to place you in the program, but you will not be placed in the program if you do not request it. Do you understand?
Yes, ma'am.
All right, good luck to you, okay? You have something for me?
Thank you, ma'am.
You're welcome. Anita, could you give this to the court reporter for her record? Thank you. All right, who's here on Adam? Augustine Adam?
Good afternoon, Judge.
Good afternoon. All right, did y'all confer with probation?
We not fully, I guess.
All right. All right, have a seat. All right. Are y'all ready to proceed on a dummy? Or is it Adam? All right. I'm trying to bring an accent to the party when an accent hasn't been funded.
I don't, it's just Adam, right? Okay, I'm making sure now I'm questioning myself.
All right. Court is calling 2022 CR 7878, State of Texas versus Augustine Adam. Can I have parties announced for the record for the state? Defense.
Marissa Giovanco for Mr. Adam.
And are you Mr. Adam?
Yes, ma'am.
Excuse me, Yaya, could I have the file stamp for a motion to revoke? Thank you.
I have my copy. Want my copy? I didn't-
All right. Mr. Adam, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Augustine Adam who was placed on deferred adjudication in 2022 CR 7878 for the offense of assault, family choking, strangulation on September 16, 2022 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Judge, before I read it, I just want to make sure that you're aware that there's also another case that is in the state too.
Yes.
Okay.
I have that.
Thank you. Yes, Your Honor, violated condition number 4 in Bear County, Texas, to Lieutenant Augustine Adam. Lieutenant there failed to report to the supervision officer as directed for the months of January and February 2023, violation of condition number 4.
How do you plead to that? True or not true?
True.
And they waive the remaining violation condition, Your Honor.
No objection. No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Do you understand? Because I want the record to be clear and to make sure that you understand whatever agreement that you worked out with the state, the court does not have to follow that agreement. Do you understand?
Yes, ma'am.
The agreement that you may have made with the state, that's just a recommendation for the court. Do you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and it is to deny the motion and continue the individual on his probation and to run this concurrent with cause number 2023 CR 5176, which is a criminal mischief state jail.
All right, is that the proposed agreement?
It is, Judge, and Mr. Adam, the criminal mischief that he is pleading to was prior to his probation. Mr. Adam has told me that he did have some struggles while he was on probation. He found himself homeless and he struggled with no cell phone and contacting his probation officer. He fully understands now that that is not an excuse and that he has to fully participate in his probation. He is motivated to do so. He has another child coming and he has never been to prison. He does not want to experience prison for the first time. He wants to be able to be here for all of his children, including the new birth of his new child. And there is a significant amount of restitution that is owed based on the criminal mischief case. And he is understanding that and prepared to do what he can to gain employment and work on paying that restitution.
All right. Do you have anything you wish to say?
No, ma'am.
All right. So where has he been since 2023?
It's my understanding, Judge, that that's when he was homeless. I don't know if he wants to speak on that himself, but
I didn't have nowhere. I was.
You want to
living on
raise
the
your right
streets.
hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Where have you been?
I've been living on the streets by myself. Like, I was
Living
doing-
on the street since when?
since 2023. My own family threw me out when I had my other kids with me. That's how I ended up on a CPS case, and I went bottom hill from there. Like, I was going through depression.
All right, but you have a child that's on the way.
Yes.
So I'm assuming, since you have a child on the way, that that child has not been in gestation since 2023 because the months don't add up.
No,
So-
this child that's coming is just a recent child that,
So help me understand, you're homeless, which means you don't have a place to stay, but yet you continue to have children
that's not.
and you're homeless.
I do certified contracting,
Okay.
so that's
And
like,
who is the mother of this child that's
uh,
about due?
her name's Laura. I don't know, I don't remember her last name. It's,
So you're having a child with somebody, you don't even know their last name.
yes, ma'am.
Okay. Any other questions?
No, Judge.
Has he done anything on probation? Ms. Abrams?
No, Judge.
All right. Court is going to grant the motion, find you guilty. His range of punishment is up to 10 years in the prison. Would you like to speak to the amount of time, counsel?
Judge, we would ask for the minimum of 2 years.
All right. Court is going to find you guilty. The court will sentence you to 5 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Destiny Cardenas.
I have no contact with her no more. We cut we went our separate ways.
I'm sorry, what?
We went our separate ways after
Okay.
that.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, because this is not, I'm sorry, because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, do you all still wish to proceed with the plea bargain agreement that's been reached?
Just step back for a moment.
Yes.
Okay, thank
All right,
you.
you have a seat in the box.
Rich, can we see that file? We're gonna
Yes.
read. Thank you. We change this one here.
Exciting and new.
Anxiety leads to constipation.
Norma? Could you resend that email on Mr. Padilla? Ah. It says sent an email. I'm searching in vain for the email. No problem.
Challenging it
Okay, in what way?
in a good way.
All right, Norma, on this one then, recall it for Thursday. Yes.
Back in the ordinance, she took the application out. Right now, that's no application. It's gonna be 1 year. State jail. Running concurrent. Thank you.
All right, state on Padilla, which is on page 1, that's being recalled for August 8th. All right, who's here on Rolando Valadez? Yes. All right, court is calling 2023 CR 7772, State of Texas versus Rolando Valadez for the state. Defense.
Joanne Akel.
And have you had a chance to confer with probation on this?
Yes, I have.
All right, could I have a file stamp for a motion to revoke, please? And are you Mr. Rolando Valadez? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rolando Valadez who was placed on community supervision in 2023 CR 7772 for the offense of driving while intoxicated third or more on November 27, 2023 for a term of 9 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge, just to give you on page 2, the fourth, number 26, that's the one I'll be reading.
All right, thank you.
Violated condition number 26, on or about the first day, January 2024, in Bear County, Texas. Defendant Rolando Valadez, the defendant failed to comply with the rules, regulations, or instructions of the Smart Start portable alcohol monitoring PAM device, and that the defendant submitted a high brag violation of 0.037 at 10:35 p.m. in violation condition number 26.
How do you plead to that? True or not true?
True, ma'am.
May remain violated conditions.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 26, the court could find it true, grant the motion, and sentence you up to 9 years in prison and up to a $500 fine?
Do you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 26?
Yes, ma'am.
Court will find violation of condition number 26 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to continue on probation, the main conditions for the scram device and move the PAM device.
Judge, may I
Yes.
mention to the court? The only issue my client has with that is that the scram device is extremely expensive. I think it costs $300 a month. He's currently paying $88 a month on the PAM device. So it's going to be very hard for him to afford the scram.
All right, my question is, why shouldn't he be in inpatient treatment?
Why should he not?
Yes.
I have no idea, Judge.
All right. Ms. Abrams,
Yes, Judge.
is there a reason why he shouldn't be in inpatient treatment? Yes.
Ask for help.
Judge,
I say yes or no.
back in March, we did the sequence screening, the drug and the alcohol evaluation, the pre-screening for the TAP. At that point, it said no TAP was required. He has completed the impact panel. There was only one
positive urinalysis for alcohol back in January. His other UAs have been negative. I would recommend that we do a tap in custody to see where that falls. To get a recommendation and then go from there possibly. I don't. Was, it looks like there was a tap done last year and it indicated intensive outpatient treatment. He has not had any treatment while he's been on his probation term. Outpatient, so I would ask that maybe we get another tap and then follow recommendations of the tap.
All right, thank you.
Judge, may I say my client is currently employed and there's a very high risk of him losing his employment if he goes inpatient. We would request if the court is considering some sort of treatment to allow him to start with outpatient.
All right. Here's the issue, Mr. Valadez.
Yes, ma'am.
You have an alcohol addiction. And you knew that if you were to test positive for alcohol, you were looking at 9 years in the prison. Either you consciously or unconsciously weighed your options. Your options were, do I drink alcohol and potentially go to prison for 9 years? Or either you did it unconsciously, but either way, you risked your freedom over a drink of alcohol, which tells me you have an alcohol issue. What I'm going to do, I'll deny the motion. I'm going to alternate amend conditions. There's going to be an update for a TAP evaluation that's going to take place in custody. You're going to follow whatever recommendations TAP has. I'm also going to order an update, not an update, but a referral to felony drug court. And that's going to be done in custody as well. And once you're released, either from inpatient treatment, if that's recommended, I'm going to ask for SCRAM in lieu of the PAM device. And there's going to be 120 sober meetings in 120 days. Is there anything else you need from the court to help you maintain your sobriety?
No, ma'am. Thank you.
You're welcome. Probation, is there anything else he needs? All right, good luck to you.
Have a seat, sir.
All right, are the parties ready on Augustine Adam?
Yes.
Court is calling 2023 CR 5176, State of Texas versus Augustine Adam. Can I have parties again announced for the record for the state? Defense.
Marissa Giovanco.
And are you Mr. Adam?
Yes, ma'am.
Counsel, in this case, have you received all of the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Adam, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented? Did you understand the document entitled Court Admonishments?
Yes, ma'am.
And did you review it with your attorney?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with offense of criminal mischief, $2,500 to $30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Adam, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's a $2,000 fine. There are no applications. This is to run concurrent with 2022 CR 7878. There's to be restitution to William Metz, M-E-T-Z, in the amount of $7,466.33. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge. We would just ask if you could waive the fine due to the large amount of the restitution.
All right, state, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. Exhibit number 1 with all the attachments.
I
Did
have-
your,
I'm sorry, Judge. I have gone over that with my client. I have no objections.
all right. State, you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we just ask that you follow the plea agreement.
All right, the court is finding you guilty. The court will sentence you to 1 year in the state jail facility. Give you credit for any time served. This will run concurrent with 2022 CR 7878. There's a $2,000 fine. Time and money will run concurrent. Restitution to William Metz in the amount of $7,466.33. There's to be no contact with Destiny Marie Cardenas, Deborah Lee Stangoni, Stangoni. Is there anything else with regards to sentencing?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You got to make better decisions in your life. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, Ms. Ferguson, on Justin Cowart,
Turn yourself into jail right now.
Day reset, where is he on the process of his evaluation? Do you know?
Sent over, or they got the motion on the first.
Wait, August 1st? Okay, all right. Can you give me a 60-day reset?
Yes, ma'am, I can do the 7th.
All right. Deputy Laura, if you'll let him know October 7th. And Norma, on Rudy Gonzalez. On that one, since he's found incompetent and based on the charge, can you give me a 75-day reset? Because I think they're going to have to transfer him based upon the nature of the charge. All right. State, Rudy Gonzalez, that's reset to October 21st. All right, the people who are remaining on the docket are Adrian Hernandez. What's happening? All right, thank you. And then we have Selena Lamone. Okay.
We're reviewing that one.
All right. And then we have Justin Zavala. Okay. All right. Thank you. Rolando Valadez.
He was just done, Judge.
That's true. Thank you. And then Wilfredo Salinas. That's on page 7. All right, so when is he set? When is his, could I see that file, please?
Number one, know what I'm saying? Number one, know what I'm saying? We are the Lord Talk with my crew. Number one, know what I'm saying? 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 There is no schedule at Law Talk Nation. You can only pay to get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pretrial on the dial. Planning always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling, unraveling. It's another day of Law Talk with Mike. Cross women's always popping up. courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing hard. We are heading into there is no Judge Simpson will tell you that being alone. We just have one question, are you a hope? Mrs. Shots, oh Mrs. Shots, oh where did you go? We have questions like on the weekends, do you work selling burritos? The law talk with my crew, we here to laugh at you. We see you in court acting all tough. Your soul says and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, we're here to laugh at you. We'll see you in court acting all tough. Your soul says citizen life must be so rough. And now Kinky Kelly is shacked up in bed with the fruit bowl. Then the cat jumped on his wiener and started causing trouble. Love exciting and new. We are and always will be the law talk with my crew.
Oh yeah, who's feeling it? Breathe deep. You can feel the tension slipping away. You feel an overwhelming sensation that you need to subscribe to Vlog Talk with Mike.
All right, the parties on Justin Zavala. All right, and is this going to be a plea on 2 cases?
Yes, Your Honor.
All right, court is calling 2024 CR 5695 and 2024 CR 6022, State of Texas versus Justin Zavala. Can I have parties announced for the record? For the state,
Andrew Harris Sadelman.
defense,
Neil Kalfas on behalf of Mr. Zavala, Your Honor.
and are you Mr. Zavala?
Yes, Your Honor.
Counsel, in each of the cause numbers, have you received all of the discovery and did you review it with your client?
I have, Your Honor.
And each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, Mr. Zavala, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney, and did you understand it?
Yes, Your Honor.
And each of the cause numbers, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
We do, Judge.
State and the cause number ending in 5695, are you proceeding on the indictment as presented?
Yes, Your Honor.
And in the cause number ending in 6022, are you proceeding on the indictment as presented?
No, Your Honor. Waiving count 1, proceeding only on count 2.
No objections.
Mr. Zavala, in each of the cause numbers, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? And
Yes,
did you sign it in all the appropriate places?
Yes, Your Honor.
And the cause number, I'm sorry, counsel. I'm assuming that in the cause number 6022, is that the case number that you're applying for deferred adjudication?
I'm applying for deferred on both of them, Judge.
All right. All right, then, and the cause number ending in 5695, did you understand that you're charged with driving while intoxicated, 3rd or more? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, Your Honor.
Did you understand if I were to grant your application for deferred adjudication, in that case, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison
Yes, Your Honor.
and up to a $10,000 fine?
Yes, Your Honor.
And the cause number ending in 6022, and count 2, you're charged with possession of a controlled substance, penalty group 1B, 200 grams to 400 grams. That's a 1st-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If the court were to grant your application for deferred adjudication, in that case, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And each of the cause numbers, if you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, Your
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Honor. Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Zavala, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
And each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause numbers, did you review the plea bargain page?
Yes, Your Honor.
According to the plea in each cause number, punishment is to be assessed at 6 years in the prison. The state is silent on your applications and the cause numbers will run concurrently. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge, there hasn't.
All right.
I filed
Then-
motions, but there were none ruled on.
All right, thank you. Then in the cause number ending in 5695, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And to count 2 and the cause number ending in 6022, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State in each of the cause numbers, any evidence.
In each cause number containing exhibit 1 and attachments.
No objections, Judge.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the documents entitled waiving consent to stipulation of testimony and stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that in each of these cause numbers, the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We will come back on October 3rd. I'll order a TAP evaluation and a PSI. Defense, is there a need for a mental health evaluation or no?
There's not, Judge.
All right. So we'll be back on October 3rd. On October 3rd, I'll make a decision on your application based upon the PSI report, the TAP evaluation, and any other evidence that's presented. Do you have any questions?
No, Your Honor.
All right, we can go off the record. Make sure that you make all of your appointments. Do not miss any appointments with probation. Do you understand?
Yes, Your Honor.
All right. Thank you for dressing appropriately for court. Is there anything else?
Nothing further, Judge.
All right, thank you.
May I be excused?
Yes, once he signs the reset form.
Okay. Thank you, Judge.
Thank you.
You're welcome.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Neil Kalfas.
Yes, ma'am.
Ah, yes. It's our old friend. I did several videos on her a few years back. No one does crazy like her. Except maybe the guy we did this morning. They're actually a pretty good match. What did I call that thing? I'll just slap a name on that. Must-see nightmare in Judge Middleton's court. Oh yeah. Quality material. Quality material. Somebody tell me if the verdict's coming back. I thought this was canceled due to the hurricane. Oh, she's got pink cuffs. Andrew, if you have to ask, go to what I don't have it under her name. I have it under Flamethrower Karen. She's the original Flamethrower Karen, and I called her that because that's her approach. Anybody who disagrees with her, she accuses of every felony in the book. That's her approach every time. But I have a got some other stuff in there, but it's good. It's a good playlist. Flamethrower Karen, check it out. Could you guys hear Judge Boyd on here? Because I had her open in another tab.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone State.
That's strong behalf of the state. We engage in the state.
Ms. Boone, raise your right hand and be sworn, please. Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
I'm actually not sure of anything.
I do see that.
Except I haven't seen this one.
JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing.
Oh, good Lord.
The first is the motions, Ms. Boone, that you had made reference the last time I saw you.
I mean, I won't say it, but you heard it, right?
Reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions, we would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those, as to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you're seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions? And do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them. I'm
giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to, With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my right. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully
Nobody cares about your feelings. I mean, nobody.
denied me, or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing is regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence, or the Probation hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the.
Oh, that's a full Karen.
And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. You know, items that were in the discovery, but if that makes sense.
That does make sense. Yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
go ahead, sir.
So I think we could accommodate that, if we could go, around September the 1st, for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
If we're gonna make this work for an October 7th trial date, Judge, I think September 1st is probably about the right time frame to have this in-court hearing, to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail to meet with her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it the conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go to answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever would be deemed suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term, and then in the presence of the state.
At 5:12 p.m. Then at 5:13 p.m., it states, do we keep discussing the points of agreement? Then at 5:25 p.m., and there's a gap in the time to the court answering this because defense was not present. So at 5:25 p.m., the jurors then sent this statement out. Disregard our last statement or question. So let's start with, have both parties had a chance to review the question and the juror's last statement?
Yes.
All right. Does anyone want the court to answer the questions that were submitted at 5:12 p.m. and 5:13 p.m.?
From the state's point of view, Judge, I believe that maybe answering the first question at 5:12 and disregarding the question that they had at 5:13, since they did send out another note saying disregard the last question.
I mean, I would agree that it looked like the third note was saying disregard the second. But I don't necessarily agree that the first one can be answered.
Well, I think just a proper answer would probably be please keep deliberating.
All right. So do you all want an Allen charge or you want them to continue their deliberations?
Continue the deliberation.
Same.
Okay, just one moment. All right, do you all want, you have all the evidence, continue your deliberation? Or do you want, you have all the law in the evidence, continue your deliberations?
State's positions, please keep I think the first one, Judge, please keep deliberating.
All right, so the court proposes the following supplemental charge. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations. Any objection, state?
No, Your Honor.
Defense, any objection?
No, Your
Any objection to the court sending the answer back to the jurors?
No.
All right. Could I have it? Oh, it's the safe one.
They can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position. And again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, in the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning to that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the fiscal evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to whom, what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to, who was it?
D. Giovanni?
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has the type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail? Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, if I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay, the court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be unless it hasn't already been done? In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, and if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get fast.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to, well, I'm in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please. So you're aware of what I had already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I had that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very wary to make these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later.
Oh, good Lord.
Tuesday, the 17th.
And that is me coming with my.
I think he'd try.
That would be
I
you
do.
Filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility when proceeding to comply with the court deadlines. So, the exhibits seeking to offer digital based on your review, to submit them on September.
I don't have it in it.
I've asked you what your thought as to when. You've provided me in agreement with that regard to that date. As you've asked questions about your motions that I haven't. Your desire to have her copies addressed at the last meeting, but I'll be glad to address it again today. You have yet to tell me that that is acceptable for you, if so why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with being to it when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding USD.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after what I did. Oh, I sent it to Anita, that's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding that as of right now, you do not have hard copies, you'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're seeking out, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Donald Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from this Boone, where the court's needs, if they wish to facilitate that through the, figure it'd be easier to facilitate it now
through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the two baggers boxes, correct? And the other jump drive that was the larger of the two, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those two thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had two bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And finally, question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It would be my intent.
I think that's the case.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you could take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC. If that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payne,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
my
there.
side also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning. All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes.
At long last, I think we've got a verdict. I swear, if they ask another question, if they ask one more question, I don't know what.
Ready?
All right, so the jury.
All
The
right,
moment
everyone,
you've all
please
been
be
waiting for.
seated. All right, ladies and gentlemen, what is going to happen at this point in the proceedings is Deputy Laura is going to get your information for you. You're going to be sequestered. You'll be placed at a hotel.
Oh, sweet.
And we will begin your deliberations at 9 a.m. My instructions remain the same. You are not allowed to discuss at the hotel that you will be staying at anything about this case. You will only be allowed to deliberate once all of you are present and are in the jury room. Does everyone understand? All right. Well, with that being said, I am going to release you for this evening, and we will come back at 9 a.m.
Oh,
To the
sweet
two
Jesus.
persons who are alternates. You will not, of course, be in the same room as the other jurors, but I'm going to ask that you be sequestered as well. All right. Anything else from the jurors? No. Deputy Laura will get the information from you all to who she needs to call. Yes. Yes. Just give that information to Deputy Laura, and she'll make sure that those items are brought. Is there anything else? All right, then we'll start back tomorrow. Excuse me, you're dimming the lights. Officer, thank you. Then what will end up happening, remember my instructions, you're not allowed to deliberate outside the jury room. Does everyone understand? And you are not allowed to think about this case outside of the jury room. Does everyone understand? And you are not allowed to begin your deliberation until everyone is present in the jury room. Does everyone understand? And alternates, you are not allowed to deliberate with the jurors. Do you understand? All right, everyone, please rise for the jurors.
I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
All right, see everyone back at 9 a.m.
Which is number one, wrong.
I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing.
All right. That hearing isn't interesting enough. The trial should be, but yeah, they don't have a microphone on her. And it's just, it's making me crazy. I can't believe these knuckleheads want to be sequestered in a bad hotel. Perhaps tonight at the Holiday Inn Express. We'll give them the insight. Well, maybe from that, maybe from some, bad coffee, and sleeping there with the bad breakfast. Maybe they go someplace with the bad free breakfast, Maybe they'll just wake up and say, you know what? The guy drove into a woman and killed her at 91 miles an hour. And he was drinking before he did it. Guilty. Maybe that's how this goes down. Oh, sweet Jesus. I can't catch a verdict. I can't catch a verdict to save my life. I don't even know if I'm going to try. I don't even know if I'm going to try tomorrow. I cannot believe if I was on that jury, I would take whoever's responsible for this and we'd have words. We would have words. That's all I'm saying. All right. There you have it. I'll look tomorrow and see, but I'm not leaving. I could have lived with all this except they faked me out with their dopey question. And then I thought, well, how long can it take? And I just kept thinking, we're getting a verdict in the next 5 minutes for the last 3 hours. Sarah Boone thing was good. Was it Sarah? Yeah. I don't know. Whatever. The Boone thing is good. But it's just a boring scheduling conference. That trial should be fun. But it's a boring scheduling conference. And she doesn't have a good mic. All I gathered from that is that I like the judge. And everybody else seems to be doing everything seems to be in order down there. She's squawking and cranking and being crazy, but not. She was just merely stupid, but not entertaining today. Don't worry, she's got potential. But today was just mind-numbingly stupid without any real good entertainment value. You got to like drop Warren Buffett in the conversation, like the guy earlier today. Take it up a notch, spice it up a little bit. Just I understand, but I don't understand. Okay, that's funny too. But I'm gonna wait until that one heats up. I can't get through that hearing. I probably could if I hadn't been streaming all freaking day. But I can't right now. That's all there is to it. If there's something fantastic, tell me about it. We'll visit it later. All right, thank y'all for coming out. I appreciate it. I'll see y'all soon.